Good afternoon, and welcome to today's edition of The Law and You with yours truly, Attorney at Law, Shellon Washington. It's a pleasure to be here again on this Saturday afternoon. I hope you guys are enjoying your weekend. I'm going to bring you today's show. Today's a special edition that I'm bringing here to you. It's obtaining a divorce while your green card is pending. I know much of my audiences are from foreign country, migrated to the United States, and this is issue that often comes up, in your immigration process. I've dealt with it myself several times for clients, and I want to share some of this information with you so it will help to protect you if you're trying to obtain a divorce, but you still have your green card pending. So let's get into it this afternoon. As I said, the topic of the day is obtaining a divorce while your green card is pending. As you know, guys, very often people come to the United States, and one of the fastest way to receive your residency is through marriage. Marriage is one of the most common method I've seen clients use to obtain their green card in the United States. Now, if you have married a U.S. citizen, it could be a bona fide marriage, and that's the standard that the USCIS use to determine whether or not your marriage was legitimate, to determine whether or not their job is to determine whether or not that marriage is a bona fide marriage, meaning a legitimate one that was entered into in good faith. So as long as they can determine that marriage was entered into in good faith, then the rest is history. But that's the first hurdle you must overcome with USCIS when you're trying to get that green card through marriage. And your U.S. citizen spouse is going to put that application in file for you to become a permanent resident. The first stage of it is a conditional residency. That's if you've been married under 2 years and you attempt to get your residency in the United States. Generally, they would issue you what's called a conditional residency card. So you will have to remove that condition after the first 2 years. So let's dissect this issue of conditional residency. Before you even get the conditional residency, you must prove to USCIS that you have a legitimate marriage and that the marriage was entered into bona fide or for good reasons, legitimate reasons, and it wasn't for fraudulent reasons, or it wasn't marriage fraud. You didn't just get married to the person just to obtain the green card. So that's the first thing. You must establish that you entered into this marriage in good faith. Now, at the initial stage, when you just got married to the person, it's not a good idea to seek a divorce at that point. It's okay if the parties are not on speaking terms. As you know, these things are normal. I've had several instances where normal marriages, the parties ended up separating, or they're not on speaking terms at some point, or there is some sort of turbulence in the relationship. And that's sort of normal. Chances are those parties are going to reconcile. And chances are whoever the spouse is that is attempting to obtain the green card, that spouse will eventually be able to get that green card. So you must know that oftentimes there are issues that arise in those marriages that may cause the parties to temporarily separate. But there are chances where the parties are going to reconcile. And if they do, that's the good part for the person who's trying to obtain a green card. As you know, when you're trying to obtain a green card, you must at all times remain in a situation where USCIS can determine that your marriage is bona fide. That's it. USCIS only need to determine that you entered to this marriage in good faith. It doesn't matter if at the time subsequent to you obtaining the green card or before you obtain the green card, you and your spouse are experiencing problems, difficulties, you separate for a little bit. Chances are if you get back together, that would not affect the green card. And if you go to an interview because the parties are separate, you just mentioned to USCIS you've been experiencing difficulties and you temporarily separated. The USCIS officer must believe your story and first determine that you entered into this marriage for legitimate purposes or legitimate reasons. So if you entered into the marriage and it didn't work out or it's having difficulties, these are normal everyday things. The only thing the USCIS officer would have to make sure absolutely is that the parties actually were married and they actually know each other's. So if the parties were in a good relationship, let's say they dated for a year and then they actually became married, so they know each other's family members, they know everything about each other's, their hobby, where your spouse work, the basic regular questions that USCIS usually ask. If that spouse who is the foreign spouse is trying to obtain that green card, and those questions when their interview can be answered, even though the parties might separate and be in separate household, but they can prove that the marriage is legitimate, then USCIS will have no other option than to grant you your green card. However, if you decide to divorce because you married to that spouse and let's say it's not working out, and there are several instances where the parties get married, but it's just not working out. And the marriage was legitimate. The marriage was for, love. They genuinely loved each other and they got into this marriage, but unfortunately one spouse was a non-resident in the United States. And on that premise, the party got married and then the US citizen spouse filed for the non-resident spouse. When the green card application is pending, the parties started experiencing difficulties in the relationship. And then ultimately, maybe the US citizen spouse said, well, I want a divorce. And I've seen this happen. I did see cases where this actually happened. The US citizen spouse said, well, I would like to divorce. I cannot continue like this. Now, if the US citizen spouse divorced pending the green card, and they contact USCIS and they say, well, I would like to vacate. I would like to withdraw my application. Then you can't do anything about it as a foreign spouse. You cannot convince USCIS that, okay, you need the application to continue. Because remember, your spouse, US citizen spouse, is the one who's sponsoring you, is the one who's going to be responsible for you financially. So if that spouse is telling USCIS, like, listen, I do not want to continue this application, I do not want to be responsible for this person anymore, then USCIS will have to honor your spouse's request to terminate the application for your green card. Okay, now all is not lost if that should happen to anybody listening to this live. All is not lost. There are other options available to you if your spouse, US citizen spouse, decide, because I can't tell you how many times I've seen this. And most of the times is either the spouse cheated, the foreign spouse cheated, the foreign spouse didn't really care about the US citizen spouse, and they just really literally married for the green card. Or it's a case where even the US citizen spouse is cheating and the foreign spouse is like, I can't deal with this. If you're going to cheat, I would like to get out of this relationship, because maybe the foreign spouse married in good faith and actually wanted the relationship to last. But the US citizen spouse is not having it and they're on the streets, like they are still single. And if that happens, like I said, all is not lost. You could permit your US citizen spouse to file the divorce, allow the divorce to go through. If there's sufficient time in the marriage, you can ask for maintenance or spousal support. If there are children involved, you can ask for child support. But if there's none of those things and it's just a flat out divorce, you can allow your spouse to divorce because you have an option that you can exercise. Now, if the parties are divorcing because of numerous issues that occur during the relationship, one of the most common ones is domestic violence. So let's say that there was a lot of domestic violence. There's a lot of fighting. There's a lot of cursing. The parties were not getting along with each other. And the foreign spouse was abused by the US citizen spouse. There's an abused spouse application that you can make. Okay? You can make an application for use an abused spouse petition. It's one of those, it's a special type of petition. So in that case, you would not need your US citizen spouse no more. And this goes for both male and female. Either one can make this application to the court, not to the court, I'm sorry, to USCIS. Either one of them could make this application to USCIS, whichever is the foreign spouse. and complain of the abuse that they suffered at the hands of the US citizen husband or wife. And this type of petition is not just limited to husband wife situation. There are other situations in which it's applicable to, which if you need further guidance, what you need to do is call my office. It's open Monday to Friday, 9 a.m. to 5:30 p.m. And the number is on the screen, 718-877-3100. You call that number if you need consultation, if you think that this might be affecting you, or you might be in a situation where you might need to do a special petition. You just call the office and I'll be able to provide guidance to you on this issue. Now, back to the situation where we're talking about the abused spouse petition. Now, in the case of the abuse could be physical, mental, or psychological. The most common form of abuse I typically see in these type of application is where it's physical, where the spouse, the U.S. citizen spouse, is either hitting, is doing physical things to the foreign spouse. I've had situation where the U.S. spouse give the foreign spouse a black eye, or so the eye was swollen, it was black. And there are instances where there's broken nose, and there's other instances with different things that happen. In that case, if there's sufficient evidence to establish physical abuse, this is easy. You literally just need to write an affidavit explaining in great detail the instances of abuse that you're complaining of. Now, a lot of times people do not report this type of abuse because the foreign spouse is often afraid that the U.S. citizen spouse is going to have them deported or something bad is going to happen to them. So a lot of times they refuse to go make a police report. And even if you didn't make a police report for domestic violence, if you never reported the spousal abuse, you all is not lost. If you just document all of this, take pictures of the black eye, pictures of the bruises, pictures of the spouse doing whatever it is to you physically, that type of evidence will help to establish that you're telling USCIS the truth and that you were indeed an abused spouse. You were abused by the hands of a US citizen spouse. Okay. Now, other than the physical abuse, you can do this also based on mental, psychological abuse. So if you have instances where your spouse is deliberately belittling you, saying disparaging things about you, abusing you mentally, telling you the most despicable things that you can imagine, all you need to do is build that case against that spouse. Record it where necessary. Take text messages and save them where necessary. All of those bad conduct or bad behavior by a US citizen spouse, if you save that information, you can use it later on to send it to USCIS, because all you have to do when it comes to USCIS is establish your case on a preponderance of evidence, which means you don't, it's not a very, very high standard. But all you need to do is establish, like, yes, there is evidence of abuse. Yes, there is evidence of psychological abuse. Yes, there is evidence of financial abuse. Like, he would not, like, for instance, there's instances where the husband brought the foreign wife from a different country and he would not give the woman any money. He would not buy her anything. All he did is put basic food in the household and nothing else. He wouldn't give anything else to contribute towards the wife's health or well-being. And then he mentally tortured the wife by telling her the most despicable things on a daily basis almost. And it kind of almost broke that client. And then by the time she came, I mean, it was at that point she was very much entitled to file that abuse spouse petition because the husband himself had refused. There are instances where somebody called and they were terrified to even be calling the office to speak to an attorney because the abuse was so grave at their home. It was the worst thing that was happening. They couldn't really deal with the type of abuse that was coming their way. So there's a lot of instances where you just have to be very, very careful, and continue to build your evidence against that U.S. Citizen spouse wherever possible, whenever necessary. All the instances, everything that happened during the span of the relationship, as long as it amounts to some form of abuse, mental, psychological, physical, any type of abuse that fits the narrative of the cases that USCIS usually look at, you'll be entitled to the abuse spouse petition. And therefore, the marriage to the spouse, to your US citizen spouse, would become irrelevant. And then you can file the divorce even at that point. Other than the abuse spouse situation, the other part of this is where there is a condition. A lot of times the condition is like I said to you earlier, if you're in the country for less than 2 years, married to the spouse, the U.S. citizen spouse, less than 2 years, you will obtain a conditional residency if your application goes through while you're living here and the marriage is under 2 years. At the time you got approved for your green card. USCIS will not issue you a full green card. They'll give you a conditional one. And then you'll have to take the conditional green card and keep it for 2 years after that, and just wait until the condition is, you have to get the condition removed. The other aspect of this is a lot of times people wondering, okay, can I get a divorce while I have the conditional residency? And the short answer to that is absolutely yes. You can quickly move forward and get a divorce while your spouse has not the American spouse, but the foreign spouse could move forward and get divorced while the conditional residency you have a conditional residency card. Either spouse could file the divorce. It really doesn't matter. The question is whether or not the foreign spouse would be able to remove the condition after they obtain a divorce, but they still have a conditional residency. And the short answer is obviously yes, you can obtain a divorce, and you can also remove the condition without the need of your spouse. Now, there are several instances where probably the parties were still married. One party filed for the divorce, but at the time of the conditional residency application, the spouses were together. In that instance, you don't have to do anything, because even if your spouse is filing for divorce pending the removal of your condition, unless USCIS requests additional evidence, chances are you'll get that condition removed even without doing anything, without notifying USCIS or anyone that your spouse has filed a divorce pending the removal of the condition. Again, like I said earlier, the standard is whether or not you entered into that marriage in good faith. That's the standard. And if you can prove on affidavit evidence or other types of evidence, if it becomes necessary, that yes, you did enter the marriage in good faith, then nothing else really matters at that point, because USCIS will grant you the relief and to remove the condition. Recently, for those who are familiar with the way immigration law works, recently USCIS has been handing out removing the condition without the need for an interview. You do know in certain instances, USCIS does require you to do an interview prior to removing the condition. And that still applies to certain cases. And those are mostly those cases where USCIS is not convinced. They're really not convinced that you actually entered into the marriage for legitimate purposes or in good faith. And in those cases, you'll find that most oftentimes the parties don't have tax returns together. They don't have joint assets together. They don't have anything to prove or establish that they've lived together. I know of instances where one party didn't change their ID, their driver's license, so they maintained their same addresses even after they were married. And it looks to USCIS like they had separate lives. So at the time they went to the interview, USCIS looked at all those documents. And so there was not much tying these people together. So USCIS decided, okay, there's nothing tying you guys together, so we cannot remove this condition. But you see, in a situation like that, it's probably best to divorce before you go towards removing the condition, because there is a time period within which you could file the divorce and try to get the condition removed, and there wouldn't be any problem, because as long as you can establish it was a legitimate marriage, look, you have children together, or look, you have a property together, or look, there's something that shows pictures, there's family, friends who knows that the relationship was actually legitimate, family and friends who can swear on affidavit that yes, this was a legitimate marriage, then you're safe. Then USCIS will still remove the condition, even though the parties might have divorced by the time the condition was ready to be removed. Most of those cases, as of recent, even where there's a divorce, you can still get the condition removed just on paper only without having to do a physical interview. So don't feel afraid that you must remain in the marriage if you're trying to remove a conditional green card. There's no requirement. You can get it. If you had the conditional residency, then you can get the condition removed. But there's certain requirements, which includes filing for a divorce or already obtaining a divorce within a certain time frame of actually getting the condition removed. Because as you know, you have to remove the condition within a time before the 2 year is up. So as long as you go ahead, file the divorce, get or obtain one, then it doesn't matter. You could move ahead with USCIS and just get the condition removed, even though you're no longer with that spouse, even though the parties are divorced or separated, whatever the situation is, it does not matter. So it's nothing to be concerned about. I've seen several instances where people are afraid, they're concerned that if they divorce, or a lot of times the spouse, in one case I know that the wife left the foreign husband who had his conditional residence. She left. She didn't wait for anything to happen. She left the marriage. And then he had the predicament where he had to establish that he had a joint life with her. So USCIS was asking for joint tax returns, joint this, joint that. And what the smart thing in that situation to do is just write USCIS and let them know that you have been separated or divorced. And then they're going to ask for a copy of the divorce. And then they may ask, okay, if you can establish that the relationship was legitimate, it was entered into in good faith, then it doesn't matter. We will grant you we will remove the condition from your green card and make you a permanent resident of the United States. So these are things you need to keep in mind, that there's no instance where you need to be bound in a bad marriage just because you're waiting to get a green card, or just because you're waiting to get a condition removed from your green card. You must understand that you can just leave and you will still manage to get the condition either removed, or you will still be able, there's other ways available to you to still proceed and get the green card, as long as you're able to establish the things that we spoke about earlier on in this live. Again, to recap, the petition for the abused spouse petition, that extends not only to abused spouse, but it extends to abused U.S. citizen parent or U.S. Citizen siblings, brothers and sisters. So if you have just a situation where a person came to the United States, let's say they went and lived with the mom or their dad, and one of those whoever the parent was, is very abusive towards them. Let's say even if they're an adult and the parent is abusive, let's say they called the cops several times on the parent because the parent, did things to them, attempted physical harm to them on multiple occasions. That's another basis on which somebody could apply as an abused person to get residency in the United States. You could say you abuse U.S. parents. You have parents in the United States who abuse you. They're U.S. citizens and they abuse you, and therefore you're asking USCIS to grant you your application to become a permanent resident based on that abusive conduct of the U.S. citizen parent or the abusive conduct of the U.S. citizen brother or sister. But just be mindful, because it doesn't extend too much in terms of the relationship, in terms of the nexus between you and the party who you can actually use to make the application off of, to say, well, the person abused you. And again, like I said before, the type of abuse that USCIS will analyze to determine whether or not you qualify for that type of petition is something that you need to be cautious of also. Like I said, if there's physical abuse, that's easy to establish, because physical abuse is exactly what it is. Somebody is putting their hands on you, somebody's hitting you, somebody is harming your person. And those type of abuse is easy to establish because there's often cuts, bruises, and there's often hospital records, or there's often police report records that you can refer to when you're establishing this type of abuse. But in the case of psychological and mental, those are a little bit more technical, because the safest way to establish those is on phone records, recording conversations, recording the rantings of that family members. And then obviously one of the key factor there that you can use is go see a doctor, go see a psychiatrist, go get evaluated and take treatment if it becomes necessary, because those things often lead to PTSD. People become traumatized from psychological mental abuse, and that's the way, some of the ways you can establish it is through treatment with a doctor, or like I said, through just ordinarily keeping recordings of the conversations, of the abuse, of anything that you see your relative is doing to you that you know legally is not correct and is causing harm. The standard is, or the bottom line is, whatever they're doing, it must cause some sort of harm to you. Because if somebody's psychologically abusing you, but you don't process it as an abuse or as a form of abuse, then obviously it's not of no relevance, because it wouldn't affect you. But if it's something that affects you because you process it as such, as you being abused, you recognize it, it's affecting you mentally, it's affecting your ability to work, it's affecting your ability to just live your life, then in that case, I would say you definitely need to establish that through medical. You go see a doctor, get yourself evaluated, keep records as much as possible, and then I think you'll be able to establish that type of abuse to USCIS. The standard is not very high, but again, USCIS, the officers are trained to detect and determine whether or not something look or resembles psychological abuse. So if you go and you just make up some flimsy narrative and say, well, you were living with your US citizen wife, or your US citizen mother, or US citizen father, and they would slam the door on you, they wouldn't speak to you, that's really not not something that would typically amount to abuse. But again, every case is individual and it has to be evaluated on that basis. All right. Now, again, like guys, thank you so much for your support. Thank you, all of you who continuously support Washington Law Firm. And just remember, guys, refer us to your friends, your family, whoever. The number to call the office is 718-877-3100. We're available Monday to Friday, 9 a.m. to 5:30 p.m. Call us and let's see if we can be of any help to your legal needs. Thank you once again so much. I do appreciate all of you for your continued support. Give me a call if you need help. Again, the number there is 718-877-3100. The office is located at 455 Utica Avenue. Consultation, free 15 minutes consultation. And again, guys, if this video has been of any help to you and you know somebody you might need it, share this video, please. Share it and like it. If you want me to continue to bring you content like this to give you helpful insight on your legal issues that you might be going through, make sure that you share this. Make sure that you refer our office to a friend, family, and neighbor, whoever might be looking for an attorney. Refer us. The number there is 718-877-3100. Thank you so much, guys, and I hope to see you again next week at 4 p.m. sharp every week for the law and you. Also, guys, if there's any particular legal issue you believe that is troubling you and you think you might need help with, just make sure you send me an send me a message here on Facebook. Send me a message telling me what that legal issue is and what you would like to have me discuss, either with myself or with one of my associates, one of my colleagues. Send the message and we will come up here live and we will discuss that legal issue for you. All right. I hope you have a great rest of your weekend. Enjoy, and I will see you again next week at 4 p.m. Thank you, guys.